Serious Survivor here. And today we're going to look at some of the gun control actions that are being put into place, and we're going to look at some disturbing trends. There's a couple of cases upcoming that are of relevance to us and that could have a dramatic impact on our ability to not only own or possess, but to keep the firearms that we already have on. But let's look real quickly at a word from our sponsors here. Take a look at this. A 5-ounce solid silver Apollo 11 coin like this could be yours free. It's Silver Month over at Noble Gold. The new administration is finally here, and one of their big things is climate change. Renewables need solar panels, electric circuits, and a lot of other gizmos that use, you guessed it, silver. So visit our website today at noblegoldinvestments.com. We're familiar with Bill H.R. 127 that was sponsored by Representative Sheila Jackson Lee, a Democrat from Texas. And some of the big things about this bill is going to require registration of every firearm that you already own or may purchase, along with ammunition. And that's a very concerning thing. If we have to register ammunition, then what happens when you shoot that ammunition? You go to the shooting range, that's just something else that they can play against us. So if I have to register that I bought 500 rounds of 9mm, and I go to the shooting range and I shoot 248 of them up, well, what if I accidentally shoot 252 of them up and my count is off? So when I re-report that to the local authorities and they come in and check my ammo, my count is off, then I'm probably at that point guilty of some type of crime, at least according to this particular firearms bill that's up for voting here pretty soon. This will also impose an additional license. You'll have to obtain an additional license to display an antique firearm in the home. If I have an antique firearm from the 1800s or even early 1900s, and I want to put this in a display case, I will now have to have a license from the government that says it's okay for me to display this firearm in my home. And it will restrict what's called assault weapons. I'm sure we're all familiar with that, and this is a very broad classification. But one of the important things about this is those that aren't restricted may be grandfathered in, but at an additional fee, once again payable to the federal government. This will also impose a mandated firearm liability insurance with a yearly fee of $800 payable to the U.S. Attorney General. And I'm sure the more firearms you own, the more this fee is going to be. And this will also impose a very detailed federal firearm registration system to which the public, all federal, state, and local law enforcement and governments and branches have complete access. So this is also concerning. Think about that. If there is a federal firearm registry created in which the general public has complete access to, then that means criminals will very easily be able to go on here, look you up, and see what kind of firearms you would have registered in your name to know whether or not your house would be a good target when you're at work one day or out for the weekend. This seems to be encouraging more crime than it will ever prevent, because the majority of people who legally own their firearms are not the ones out committing the crimes, and I think we all understand this at this point. That bill is going to be up in front of Congress before long, and a lot of us are hoping and praying that this is not going to go through, because this is going to make it almost impossible for the average citizen to not just own a firearm. They're probably not going to completely take the right away. They're just going to make it so expensive and so difficult that the majority of people are not going to be able to complete the process. And there is also call for mental health evaluations on every firearm owner. And what this means is not just when we go to purchase a new firearm, am I now going to have to probably pay a psychiatrist or psychologist their fee, then I'm going to have to be evaluated by this person to determine whether or not it's okay for me to possess or legally own a firearm. I would like to see that same test imposed on all of our public officials just to be able to attain or hold the office they're in, because I feel quite confident at this point in time the majority of our politicians would not pass a sanity test. But one of the most disturbing things that we're going to see If you think about that HR 127, let's say that it does pass, but let's say that a lot of the restrictions in it are watered down or are pulled out so that it can pass. Well, there's something else that's coming in front of the Supreme Court in the next month or two that's of grave concern to anyone who's keeping an eye out for these type of issues. We know that the Fourth Amendment gives us a guarantee or a right against warrantless searches of a person's home. This amendment ensures that local authorities, government or federal authorities, I should say, any type of authorities have to have the appropriate warrant. They have to have the appropriate documentation to be able to enter my home and search it. They have to have probable cause and believe they will discover specific evidence of a crime in my home. There are some exceptions to this right, though. There are some circumstances in which a warrant is not necessary for my property or my area to be searched. And the first one of these is called an exigent circumstances exception. And an example of something like this is if a police officer looks through the window at a home or sees through someone's window that one person is about to, say, stab another person, the officer can then burst directly into that residence to prevent the attack. There's also what's called an emergency aid exception. If the officer looked through the same window and saw the resident collapsing from maybe a heart attack or something similar, then the officer could legally run into the house and administer aid. Neither of these cases violate the Fourth Amendment, but there is a much broader explanation or a much broader section to these exemptions, and this is called community caretaking, the community caretaking exception. The community caretaking exception is derived from a case in which police literally took a gun out of the trunk of an impounded vehicle without first obtaining a warrant. The Supreme Court held that there is a community caretaking exception to the Fourth Amendment's warrant requirement because police perform community caretaking functions totally separate from the detection, investigation, or acquisition of evidence relating to the violation of a criminal statute. The court then held that police activity in furtherance of these functions does not violate the Fourth Amendment as long as it's executed in a reasonable manner. And that's some of the things that we hate to see in descriptions of law is words like reasonable or reasonably. We hate to see those because that is such a broad description that anything can be made to fall into those categories. Now, unlike the first two exceptions that we talked about briefly, the first two exceptions are for immediate emergencies, someone going to be injured by someone else, or someone in dire need of medical assistance. In the Supreme Court case we just spoke about, there was only a concern that possible vandals might have broken into that impounded car and stole weapons that were in the trunk. And this is why the community care exception is so much broader than the other two. And for all three of these exceptions, they do allow for warrantless searches as long as the police officers act, quote, reasonably. Reasonably, once again, is one of those terms that there is no definition for. We do not have a definition for what is reasonable and what is not when it comes to search and seizure of our property, especially with the definition of these three exemptions that we talked about. So this is one of the easiest constitutional standards to meet, since it's a significantly lower standard than having to have actual probable cause, which is required for a warrant. As long as an officer might reasonably think that a warrantless search will alleviate a danger to the community, the search is considered constitutional. So if they believe that weapons in your home are a danger to the community, then a warrantless search is considered constitutional. Now, there's a vigorous debate right now as to whether the community care exception can actually apply to searching a person's home as well as their car. It applies to your car now. Vehicles have always had less Fourth Amendment protection than homes because homes are considered a person's most private area. Federal courts have been divided on this question, and the Supreme Court has not ruled on it until now. The court just announced it will hear arguments next month in a case that presents this issue, and that's Caniglia versus Strong. The case is Caniglia versus Strong, if I said that right. In this case, Mr. Caniglia was arguing with his wife and put an unloaded gun on the table and said, "Shoot me now and get it over with." His wife called a non-emergency number for police, who arrived shortly thereafter. The police disagreed about whether he was acting normal or agitated, but they convinced him to take an ambulance to the local hospital for evaluation. The police did not accompany him. While he was on his way to the hospital, Miss Caniglia told the police that her husband kept 2 handguns in the home. The police decided to search his home for the guns without obtaining a warrant. Miss Caniglia's consent to have the police search the home was legally negated because the police untruthfully told her that her husband had consented to the seizure of any guns, which he did not. The police located and seized the 2 guns. So Mr. Caniglia sued for his violation of the Fourth Amendment right to privacy and his Second Amendment right to keep handguns in the home for self-protection. The First Circuit Court of Appeals sided with the police. The court wrote, "At its core, the community caretaking doctrine is designed to give police elbow room to take appropriate action when unforeseen circumstances present some transient hazard that requires immediate action. Understanding the core purpose of the doctrine leads to the conclusion that it should not be limited to the motor vehicle context. Threats to individual and community safety are not confined to the highways." Now, it is true that the police do need some discretion in carrying out their difficult jobs that they have, but they are also agents of the government, and their power is supposed to be restrained or limited by the Bill of Rights. The Fourth Amendment is supposed to protect the home above all other places. No matter what someone's views on gun control may be, the Supreme Court has clearly held that the right to keep handguns in the home is at the core of our Second Amendment. Unlike the exigent circumstances and emergency aid exceptions, the community caretaking exception is not limited to circumstances where there is no time to apply for a warrant. And the question of what sort of caretaking falls under this exception is extremely vague. Will the police be able to use it, for example, to conduct warrantless searches of political protesters' homes? The Supreme Court is going to take a very close look at this case, and there's a good chance that it will overrule the lower court's decision. But should they not, then we're in for a pretty hard ride. With H.R. 127 and the other gun bills that are being passed or attempted to be passed right now, if those bills are passed that impose very stringent restrictions on the possession, the purchase, the ownership of a firearm and ammunition, then it only seems to reckon that the police will use the community caretaking exception to search the homes without a warrant for people they suspect may have ammunition, any type of firearms that are not registered. And this is going to open the door to a complete loss of our rights, not just on the Second Amendment, but on the fact that if this does pass through, if this is upheld, then we are not safe in our own homes anymore. And that is the only place that we're truly protected by the Constitution, in our homes. But if this goes through, then we will not be protected there. The police will at any time, under the community caretaking exception, saying they think it's better for the community because someone might be a danger without reasonable cause, and take control, not just take their firearms, but most likely incarcerate the people who had the firearms. So this is something we really need to look at, and it's just something I wanted to put out there. Thanks a lot for watching. God bless. And for now, Seer Survivor, out.